7. Regulation. Section 77. Generally, the power of the states to regulate business trusts in various respects is settled. No unreasonable discrimination arises from a statute which regulates the activities of business trusts as distinguished from traditional kinds of trusts. 8. And the right of a business trust to do business within a state as a legal entity may be conditioned upon its compliance with the laws governing such organizations. However, it has been held that the sale of its own shares by a business trust does not constitute doing business within the meaning of regulatory statutes. The applicability to business trusts of statutes relating to carrying on business under a fictitious or assumed name is discussed elsewhere herein. Section 78. Under statutes relating to corporations generally, business trusts have frequently been held to be subject to statutory regulations of corporations and to provisions aimed primarily at corporations. A state has the power to include such trusts within the definition of corporations. Accordingly, business trusts have been held to be corporations within the meaning of statutes requiring corporations to file reports and pay fees. They have been regulated as corporations under general constitutional provisions that the term corporation should include all associations and joint stock companies having powers and privileges not possessed by individuals or partnerships, and by virtue of constitutional and statutory provisions that the term corporation should be construed to include all associations and joint stock companies having any powers or privileges of corporations not possessed by individuals or copartnerships. However, a business trust has been held not to be a corporation within the meaning of a statute regulating corporations and defining the term to include all joint stock companies or associations having any powers or privileges not possessed by individuals or partnerships. A business trust has been held to have the right to do business as a building and loan association without becoming incorporated, under a statute expressly authorizing any unincorporated association of individuals to carry on such business, subject to certain regulations. And a statutory prohibition against the operation of a cemetery for profit by a corporation has been held ineffective to bar a business trust from so doing, under a statute expressly authorizing a trust to acquire, hold, and deal in real estate, and to carry on any lawful business and, generally, to do any lawful act in relation to the trust property which an individual owning such property absolutely might do. Further, it has been held that a business trust does not come within the prohibition of a statute imposing penalties on corporations for holding real estate in a manner forbidden by the state constitution. Persons who convey land to a business trust, receiving in consideration of the transfer shares in the trust which are not, as a matter of judicial determination, valueless, and who permit the trust to enter upon the land and spend considerable sums of money in its development, have been held as stopped to subsequently assert the invalidity of their deed on the alleged ground that the trust was in fact a corporation and had failed to comply with the statutes requiring the granting of a certificate of incorporation before doing business. Section 79. Under statutes relating to foreign corporations, a business trust seeking to carry on business in a state other than that in which it was organized, as an entity clothed with peculiar rights and privileges not possessed by individuals or partnerships, may be subjected to the conditions, such as the procurement of a certificate of authority, which are usually imposed upon foreign corporations. Treating a foreign business trust as a foreign corporation for the purpose of such regulations does not violate any constitutional rights for the trust or of the members thereof. Specifically, such legislation does not violate the Privileges and Immunities Clause of the United States Constitution. Furthermore, the fact that by the Constitution and statutes of the state where a trust was organized, it would not be deemed a corporation, has been held to be without significance in determining the applicability to the trust of local statutes and constitutional provisions relating to foreign corporations. A business trust organized in another state has been held to be a foreign corporation and subject to the regulations imposed by statute upon foreign corporations doing business in the state, and also subject to the same penalties as foreign corporations for failure to observe such regulations. However, the view has been expressed that since a statute requiring foreign corporations to comply with certain regulations and prohibiting them from maintaining actions unless they have done so is rigorous, if not penal, in character, it will not be construed so as to be applicable to a business trust unless the intention so to apply it is clearly manifested in the statute. Moreover, some courts have taken the position that business trusts are not subject to statutory regulations of foreign corporations, even under a definition of the term corporation as including all joint stock companies or associations having any powers or privileges not possessed by individuals or partnerships. Section 80. Under Blue Sky Laws and Securities Acts, statutes regulating the issuance and sale of securities, commonly known as Blue Sky Laws, are generally construed as applying to Massachusetts or business trust and as requiring such organizations to comply therewith as a condition of the right to sell their shares. Some such securities acts, or Blue Sky Laws, are specifically made applicable to business trusts, and particular language of other acts has been construed to include business trusts. Thus, the shares of a business trust have been held subject to regulation under Blue Sky Laws applicable in terms to an investment company, or an issuer of securities, or generally to any person, firm, association, company, or corporation selling securities or offering them for sale. A Blue Sky Law applying to business trusts and accepting from its operation testamentary trusts and trusts created by judicial decree is not, for that reason, unconstitutionally discriminatory. Such a statute, construed by the court as applying to a business trust, is not therefore an unconstitutional abridgment of the right to own property and to contract freely with reference thereto, under a Blue Sky Law providing for the licensing of investment companies and dealers, by the Bank Commissioner. A Massachusetts or business trust organized in another state has been held to be entitled to a license, and the refusal of the Commissioner to issue the license on the ground that the law did not authorize such an organization or recognize the legal existence thereof, was held to be erroneous. However, a different view has been taken in a jurisdiction in which a business trust is regarded as a corporation. Under particular circumstances or with regard to certain transactions, Blue Sky provisions may not apply to a business trust. Thus, in view of another statute requiring a permit from the supervisor of building and loan associations, after his approval of the plan of business, as a condition of the right of an unincorporated association to carry on the business of a building and loan association, a business trust proposing to engage in such business was held not to be required to comply with the Blue Sky Law relating to corporations generally. Section 81. Consequences of, and who may assert, violation of statute. A trustee's sale of shares in a business trust without a permit from the Corporation Commissioner as required by the State Securities Act, under circumstances amounting to fraud, has been held to be absolutely void. However, as regards the rights of a bona fide purchaser for value of real property from the trustees, the failure of the trust to obtain a permit required by the Blue Sky Law does not invalidate a conveyance to the trustees or the conveyance by them. While creditors of a business trust may attack the validity of securities issued by it in violation of a Blue Sky Law, mere strangers may not. A person contracting for shares of such a trust can raise the question of the failure of the trust to comply with the Blue Sky Law, the principle that ultra vires transactions of corporations may be questioned by the state only not being applicable in such a case. Such a trust cannot recover on a negotiable instrument given for the purchase price of shares sold in violation of the Blue Sky Law, and a person purchasing shares from a trust which sold them in violation of the Blue Sky Law may recover back the purchase price paid therefor. In such a case the subscriber is not in pari delicto, and the defense that the purchaser of the shares was in pari delicto is not available against an action or counterclaim for the purchase price of shares illegally sold, since the Blue Sky Laws are intended for the special protection of such persons. Section 82. Federal Securities Acts. The Federal Securities Act of 1939 and other related federal legislation clearly include business trusts within their operation. Thus, the Federal Securities Act of 1933 specifically includes within its provisions trusts in which the beneficial interests are evidenced by securities, and it is clear that shares in a business trust are securities within the meaning of this federal act. The Securities and Exchange Commission is not precluded from exercising the power conferred upon it by statute to set terms and to condition its approval to a petition for delisting a security from an exchange, merely because such terms would give the shareholders of a business trust the right to vote upon a matter as to which they have no voting rights under the instrument of trust.